he is a lawyer at Fay Sharp, which is one of the biggest law firms in Ohio that deals with intellectual property. That's a topic for FPS this year, international. He graduated from Notre Dame University as a civil engineer and went on into law school. So I really appreciate you coming at short notice, and he'll just tell us more about himself and the topic.
Okay, well, this is my first time to use a smart board. So when I mess it up, you guys can steer me the right way, okay? Anyway, intellectual property law. It does have that word intellectual in it. It doesn't mean I'm smarter than any other lawyer. It just is one categorization for an area of the law. And as you'll see here, we break that up into anything in the law you can do, just like a research paper or any topic. You always go back to your basics. Who, what, when, where, and why. Right? You sit down and they say, write me a 5-page paper for tomorrow. And you get to pick the topic. Pick the topic and then sit back and you say, well, who's in it? What was it about? When did that develop? Where does it take place? And why are we talking about it? Right? So what I'm going to try to do is, in all the different areas of intellectual property, we'll generally follow those basic questions. Right? So, intellectual property generally covers these 4 areas. There are others. But generally we have patents, trademarks, copyrights, and trade secrets. And as an intellectual property lawyer, we're a little bit unique because, for example, in our law firm, every single lawyer, there's about 40 of us, everybody has a technical degree of some type. So we're either engineers, biologists, chemists, computer science majors, many of them with multiple undergraduate or multiple technical degrees. So we have some PhDs, meaning they've been in school for a very long time. And then on top of that, we all went to law school. So when we talk to general lawyers, the main distinction is that we can also talk to the engineers and the scientists. The general lawyers probably have a little harder time doing that. And so my job, as I see it, is to serve as an intermediary between the engineer or the scientist and the patent office, or between the engineer and the scientist and the judge or jury if we ever end up in court. So it's important for me to, I'll never understand everything about how you make a laser diode. You know, I studied it way back when, but I'm guaranteed that since 1980, which is when I got out, things have changed just a little bit, right? So there's no way that I can know all of that. However, that particular engineer or scientist lives and breathes that every single day. And because of that, he's got the knowledge way above mine, but if I understand the basic principles behind the engineering or the science, it's up to me to communicate that to a judge or a jury or a patent examiner. So we'll walk through that here in a second. Trademarks, why they got thrown in with intellectual property, I have no idea. It's just historical in nature. But trademarks, these are kind of a fun thing that we do. It's a word or a logo used in association with goods or services. And we'll run through those. I put some fun stuff at the end of the presentation. Talk about that a little bit. Copyrights are a type of protection that, in fact, the type of protection is mentioned right in the name. It prevents others from copying your expression of an idea. You can't copyright an idea, but you can copyright the expression of an idea. So, for example, West Side Story and Romeo and Juliet. Anybody ever heard or read it? Anybody? Yeah? Okay. If you think about the basic theme that goes through that, it's the basic same type of story, right? Boyfriend, girlfriend, whatever, lovers, and they end up, things go awry, and families get involved, and things fall apart, and then there's a tragic ending, right? It's the same idea or theme behind that, and you can't copyright that. However, my expression of that, if I wrote West Side Story, or if I wrote Romeo and Juliet, or I wrote one about Frank and Jane, right? Same type of a story. My expression of that, I could copyright, right? And so it would prevent anybody else from actually copying it. Somebody else can write the same concept, the same idea, they just can't copy my material and use that over. Right? And the last thing is what's known as trade secret. And a trade secret is when you have a particular process, idea, concept, maybe customer lists, maybe a particular way of making something better than other people do, what we call a competitive advantage. If you have a competitive advantage, sometimes you don't want to tell the world about it. So what do you do with a secret? You lock it up. And you lock it up because it's to my advantage that I'm the only one who knows about it, and I can make my product better, faster, and less expensive than somebody else. So, if you walk into most major companies in the US these days, just like here at the school, you can't just walk in the front door, right? You got to turn around and give them your name, give them an ID, and usually hand in your cell phones, right? Or your computers or anything, any cameras. And the reason being, that company wants to protect whatever's inside those doors. So that's their way of trying to protect it by keeping it all secret. So, in the end, out there in this big world, the big round boundary is what we call know-how. Just think of it as any and all information about a particular subject. Right? Then within that, there are different breakdowns. All the different types of intellectual property we just quickly mentioned there would fall inside this. So there's trade secrets out here. There can be copyrights, there can be trademarks, there can be patents. And you'll also see, most importantly, sometimes these overlap. And we'll talk about that a little bit too. Right? So, patents, that's our first one. And we usually talk as an intellectual property attorney about patents first because to be a true, what we call a patent lawyer, you have to have that technical background. So I would probably tell you that about 90% of what I do day in and day out requires my engineering degree as much as it requires me to be a lawyer. And not so much on the trademarks, you don't have to have a technical background. Same thing with the copyrights or even the trade secrets. But we do have patents. So how do you know that there's a patent involved? Well, typically when somebody has patented a product, we have them put a notice to the world out to the product. And you write US patent number 9, 1, 2, 3, 4, 5, 6. That's a made-up number, I know. But in the US, we just went over 9 million patents that have been issued since the late 1700s. And obviously that's what they require on something new, we would say novel, something useful and not obvious. And so criteria of what is deemed to be patentable is, well here, let me go back one. Who came up with patent? Why do we even have it? Well, just like any law, if there are no laws in society, we've got chaos, right? And with chaos, somebody finally sits back and says, you know what, we've got to put everything in a little bit of order. And they said, all right, who's going to help us do that? Well, they come back and they say the framers of the Constitution. So everybody knows the Constitution is the highest law in the United States. And from that, there are just these broad general principles. And then off of that, Congress comes in, and Congress will make the specific laws to then take those concepts and put them into action. And then if there's a dispute over it, it often will end up in the courts. So the courts generally don't make law, but they interpret the law. So they sit back and they judge as to what that, if this is what the law says, and this is what occurred, what should be the result of that, right? So the people who benefit from this, these are the inventors, these are the scientists, more importantly, these are the companies. They're all sitting out there and they say, I put a lot of money into researching and developing this new idea. I'm just not going to go out and start selling it and give it all away. It cost me a lot of money. You think of any particular drug out there in the market, and if I've got asthma problems, and I need to take a particular drug for that. That takes them years and years and years worth of research to get the right drug to treat my asthma. And when they put all that money and time and effort into it, they want to make sure that they get a return on that. And so patent law is one way that they get that return. And to do that, we're going to jump ahead. So, again, Constitution sets up the idea in Article 1, Section 8. It's to promote the progress of useful arts by securing for limited times to inventors the exclusive right to their discoveries. Right? This is kind of an interesting thing, is with patents, you're talking about technical ideas, and yet they refer to it as useful arts. So it's a little broader term than just new ideas, right? And what they do is they secure for a limited time. And as you'll learn here, it's 20 years from the day that you file for a patent application until, 20 years from filing. If you've paid all your fees and everything else, that's when the patent will expire. And during that time frame, if I have a patent on a new asthma medicine, I can prevent other people from making, using, selling, importing it, offering it for sale. So it's a pretty powerful tool. Let me try to emphasize the one thing that it doesn't do. It doesn't say that I have the right to make it, use it, and sell it, import it, and the like. I have the right to exclude somebody else from doing that. All right? And somebody said, well, what difference does that make? All right? So here's a real-world example for you from way back when. Light bulbs were originally kind of a vacuum inside of a glass bulb. And inside that was a filament, and you put electricity through it. And because of that, you got light to be emitted out. Right? Well, let's presume that the first ones lasted 100 hours each. Right? Along comes somebody else a few years later, and they say, if you make that particular filament out of a material called tungsten, it doesn't last 100 hours, it lasts 10,000 hours. For you guys, you're going to see it more and more than anybody else. Incandescent lamps or lights are going to be gone here soon. You're having a harder time finding them in stores these days because we went to fluorescents and now we're going to LEDs. And you see LEDs everywhere. Why? Because they're more efficient. They last longer. They're a little more expensive right now, but over time, the price of that will come down because they're learning how to make that better, faster, cheaper. Right? And because they're the first ones to do that, Congress says, here's what happens with a patent. You write it down, you describe it to me, you put that in the patent office, and if they say that it's new and different, non-obvious, and they grant you a patent, now 20 years down the road when that patent is expired, everybody in the world has read it and they understand how to make and use it. So there's this little contract going on between the inventor and the U.S. government through the patent office that says you'll get a patent if you follow the rules, and then you're going to be able to exclude others for 20 years from doing that. All right? So here's the guy with the light bulb out there, the basic, any type of carbon filament in there. And he can, let's presume he gets a patent on it. We'll call that Thomas Edison, all right? And he gets a patent on it, and along comes the guy with the tungsten filament. And it's much, much better. And you say, if Thomas Edison got a patent on the first one, he can prevent the guy doing the other one because he still has a vacuum inside that glass tube. He's still sending electricity through this filament. But what happens is he can prevent them from making their bulbs. They, in turn, though, can get a patent on the tungsten because that's new and different. It's better. It's not obvious. Nobody ever thought of doing that before. And it's obviously very useful. So what you end up with is they can't make their product without a license from the first guy. And a license is just that. It's a permission to make it, use it, and sell it. And so you usually end up with what we call a cross-licensing arrangement. One great idea is dominant over the other one, but to do an improved version is what everybody really wants. And therefore, for each of them to make it, what the other guy has, they enter into a cross-licensing arrangement. So cross-licensing or licensing in general, it's just a contract. It's an agreement that we're going to do this and you're going to do this in return. All right? So all of this gets codified then as we indicate by courts, 35 U.S. Code that has all the patent laws in it. If you guys ever want to look them up. when you can't sleep at night, you're going to have a boring night ahead of you, read the 35 USC. It's very boring, let me tell you. Then you get to the courts. Well, patent law is very unique in the standpoint that if there's ever a dispute over it, those disputes go to district courts in the United States, not a state court, but the federal courts. If there's any further dispute on that after an appeal that would come from those appeals go to one court in the country, and that's called the Court of Appeals for the Federal Circuit. So it's kind of unique. If I have a problem where fair housing, right? I didn't fairly sell my house. There's a federal law on that. If I violated that, I can end up in federal court because I violated the federal law. If I want to appeal that, I usually, in Ohio, I would go from U.S. District Court for the Northern District of Ohio, and then I would end up in Cincinnati at the Sixth Circuit Court of Appeals. And then from there, if I still have a problem with it, I end up at the Supreme Court of Ohio, or Supreme Court of the U.S. However, if it's a patent issue, it doesn't go to the Sixth Circuit. It instead will go from U.S. District Court, Northern District of Ohio, to Washington, D.C., which is where the Federal Circuit is. And then if there's problems beyond that, it goes up to the Supreme Court. All right? And the reason you do that is that actually helps to bring uniformity all the way across the country on patents. So, what's a patent all about? It's any new and useful. By new, there's actually two frames of this. One is brand new, and then those things that would have been obvious to somebody else. So any new and useful, a process, a machine, a manufacturer, a composition of matter, or an improvement of any of those. So if I have a series of steps on how to put a metal coating onto a surface, I can patent the actual process itself. I may have a machine that actually applies that metal coating onto a substrate, onto a surface. The machine itself could be patented. If I have a manufacturer, that's the resultant product from the machine. That might be patented. If I have a composition of matter, a new material, that too could be patented, or improvements of it. So we're going to jump through all of these and we'll take a look at some examples at the end. Things that you cannot patent, a mere expression of an idea. So for example, I want to patent the ability to go from Earth to the moon. Who wouldn't want to do that, right? Great idea. But it's just that, it's just an idea. Or an actual case that occurred way back was, I want to be able to send information or data over the airwaves to somebody else. Right? It's an idea. And that's all it is, it's just a general idea. If you can tell somebody how to actually do that, and the specifics on the transmitter and the receiver, you could probably get a patent on the transmitter and the receiver, or maybe even process something like that. But just the idea itself, you cannot get a patent on that. Laws of nature, things that occur naturally. So, we can't patent humans. Even though there's all kinds of new genetic coding and everything else going on, you'll see lots and lots of development in the law these days over where do we cross over from mere science to being a law of nature. Right? And the thing is, all these laws were written way back when a lot of this stuff didn't exist. And so sometimes the law has to adapt, or sometimes Congress has to come back and say, give me a new law. We've never run into this before. So can you change the law for us and help us get around it? Right? Another thing that you can't patent, forms. Excel spreadsheets. If you just look at a printout of an Excel spreadsheet, right? It's nothing but a bunch of columns and a bunch of rows. That form itself cannot be patented. The computer software, however, that takes when you put the information into an Excel spreadsheet, that could be patented. Because that said to automatically add these or perform whatever algebraic function you put into those. So the form itself, measuring cups, that's a type of a form. That cannot be patented. So, where does it get patented? Well, if I have a U.S. patent, That patent is good in the United States and all of its territories. What about outer space? Think it should extend to the outer space? I don't know. That's right. Our territories on the moon, you may want to do that. Or up in the space station. There's lots and lots of research that goes on up in the space station. Do we want to prevent somebody else from doing that same research up there? Maybe, maybe not. I can tell you this, the law isn't real clear on that. So when they run into problems like that, what happens? You go and you talk to a judge and you say, hey judge, here's the law, here's what's going on. How should we resolve this? Should we allow them to do it or not? And that's what the judge sits back and tries to interpret. And sometimes when the judge, he doesn't do it right, sometimes he'll get criticized for that. But if he does get criticized, then Congress can step back and say, hey, we don't like the way that's going, let's change the law a little bit. You know, that law was from 1920. It doesn't apply to today's technology. So maybe we need to update that. So, to get something patented, you have to actually work through the U.S. Patent and Trademark Office. So for example, when you finish with your undergrad degree in the technical area, like science or engineering, you can go and be a U.S. patent examiner. Or you can do it like I did. After law school, I actually went back and I worked at the patent office as a patent examiner. And all I'm doing is I'm reading other people's applications for what they want to try to patent. And they come from all around the U.S., they come from all around the world, and I read them, and then I go out and I search for something that's similar to it, and then I get to be kind of a quasi-judge, and I say, yes, it's patentable, or no, it's not. And if it's no, it's not, and they disagree with me, they can appeal my decision. And they can appeal that through the patent office. And ultimately, they can get out into the courts also. Patents, in general, are not state court issues. It's a federal issue. And so, if we have anything through the patent office, through the federal courts, and then through administrative patent issues, again, with the patent office. All right? Why do we have patents? And again, it's to promote the useful arts. Probably the biggest thing is it rewards or compensates the inventor of the company who's put in that research and development. Years and years ago, Jobs and Wozniak came up with the Apple computer, and they did it in their garage. When they came up with that, they had some great ideas in there. Well, it was a lot of years that they put time and effort into that. They want to be rewarded for that. So they filed a lot of cases, and they actually secured a lot of patents. And believe it or not, from that small garage, out come lots and lots of jobs. Take a look at Apple Corporation. Anybody here have an Apple phone? Yeah. Anybody not have an Apple phone? I like you guys. I have the Droid. All my kids, everybody else has the Apple in the family, so I'm the oddball. But Apple is probably one of the best marketing companies in the world, and that's going to take us into one of our next topics here in just a second. So, as they say, BC Comic, used to be comic strips, I don't think anybody reads them anymore, but what do I need to apply for a patent? Smart aleck answer is need an invention. So, we'll quickly run through these. The interesting thing is, somebody puts a lot of time and effort into developing the idea. Oftentimes they may get a patent, and that patent is almost too early in time because the product doesn't become useful for many, many years later. All right? So just take a look at some of these things that you still have around today, and take a look at the years when they were first developed. X-rays. The ability to look inside through the skin and see the internal bone structure, right? 1895. So even if you got a patent on it, that patent is long since expired back in 1915. Ask air conditioning, airplanes, the Wright brothers, right? The liquid fuel rocket, frozen food. Anybody know who came up with the fast frozen food idea? Any guesses? Anybody? You go down to the frozen food aisle at the grocery store and you see the name Birdseye. Right? You ever heard of Birdseye? No, well, they were back then because he was the first guy to figure out how to pick the peas and stuff right off the plant and immediately take it and flash freeze it. That's what made too, such a big thing. All right, take a look at that was done, 1924. Okay. Television, and by that I mean the old cathode ray tubes as we see, the old type televisions, not your LCDs and LEDs and all that. But anyway, first developed back in 1926. These are kind of making a comeback, believe it or not, right?
Yes.
I used to have vinyls like everybody else. I probably should have brought in a proper set here. When I was in college, we had what we call 33 1/3 albums. And they were about yay big. And then they came in a cardboard sleeve. I'm sure you've seen them somewhere, right? And we used to take those and you'd store them into milk crates. Right? And how did you get the milk crates? Well, you borrowed those from the grocery stores. You know, they're sitting out there. Is that right? Am I right?
Yeah.
Milk crates were sitting out behind them. Well, the guy who made the milk crate now lost that. and so it became a real big thing. I work with a company down here in Canton, Ohio. And if you go into a Costco or Sam's Club, they developed what they call a caseless shipping for bottles. So instead, they have a wooden pallet. You fill all this milk into these plastic bottles, and the bottles can stack one on top of another, without any plastic crates. So the ability to eliminate milk crates is huge when you go to sell milk in a big store like that, right? Because you don't need to make the crates anymore. They're not so worried about people stealing them like we used to, we were borrowing them way back when. But you'd have to bring them back, you'd have to clean them. You'd have to ship them from the store back to the dairy plant. So here's a big empty truck, and all I can put in it are empty milk crates. And kind of a waste of time to do that. If you don't have to do any of that, all you have are wooden pallets. You've got plenty of room in there, you can use the truck for a completely different purpose. Great idea. Radar, just prior to World War II. Nobody really knew anything about it before that. Suntan lotion, 1936, you still use disposable diapers. Well, that was kind of a consortium of a couple of inventors and Procter & Gamble out of Cincinnati. Jet engines, 1937. Teflon, 1938. Does everybody know what Teflon is? Polytetrafluoroethylene, PTFE. And it's actually made by DuPont, I think. And Teflon is the slippery surface that you put inside of cooking utensils. Right? So if I fry an egg, I usually put a little butter or oil in there to make the egg kind of not stick. Well, that non-stick surface is known as Teflon. So the actual material is known as PTFE. There's a patent on that, well, long expired. Or putting it onto all kinds of different items to make them slippery. That's not. Microwave ovens. Lots of you have those in your house, I'm sure. Look when that thing was actually invented, many years ago. Anyway, a few more there. Cell phones, 1970. An MRI, magnetic resonance imaging. Email didn't come around until 1971. A magnetic turn. Post-it notes are still popular, yet 1980. The Internet, or the World Wide Web, 1989.
How was there email if there wasn't internet?
How was there? There wasn't.
How was there email if there wasn't internet?
Well, this tied them all together. This could go from one machine to another, but it didn't become a World Wide Web. Right? Somebody decided that one of the best ways is you wouldn't cable everything together, but you used this computer, this computer, this computer, and you kind of had hosts between them. So that's the World Wide Web, or the Internet. Right? I can have, within this building, email from this room to the next room. When I then take it outside and put it on different computers, then it becomes the Internet. Right? Yes?
What does it mean by driverless car?
Well, I threw that one in there because just everybody's heard about Google doing that, right?
Yes.
Yeah. That's the real big thing these days is the driverless cars by Google. And their idea is that essentially I can sit in the passenger seat or I can sit in the driver's seat, but I don't control the car. I may type in my information of where it is I want to go, and then that's it. It's done. The car takes me there. I don't press on an accelerator pedal. I don't press on a brake. I don't even steer anything. The car just does it itself. So that's a driverless car. And yet, the concept for that is many, many years old. Smartphones. You guys got smartphones? Take a look when they first were developed. GPS is 1993. All right. We're going to run way out of time, so we're going to keep moving fast. Trademarks. Sometimes you guys will see it out there in products. It's either a TM or an R. We'll talk about that in just a second. So, again, who decides to protect trademarks? Well, craftsmen and guilds. And so the Constitution puts it together. Again, Congress creates the laws for that, and then the courts will interpret it. It's a word or a logo or a combination of a word or logo used in association with either goods or services. So, anything in commerce in conjunction with goods or services, it's usually an interstate. That's federal trademark protection, meaning it crosses the state lines. If it's only in a part of Ohio or all of Ohio, but it doesn't go across the state borders, then it's intrastate, and there, in fact, you might have state trademark protection. Typically, though, most everything in the United States today is interstate, and therefore you seek federal registration. You can register your trademark, or you can go common law. And what that means is, I come up with a new name for Teflon onto a cooking pan, right? And I'm going to call it Slippies. Right? It's really not a very good name because it's somewhat descriptive of what the product is all about. Whereas film and a camera, before digital cameras, you'd buy film. The name for that was Kodak. Has nothing at all, Kodak has nothing to do with describe the product itself. So those types of marks are very, very strong. It has up with Apple, very, very strong in the trademark area. And it really has nothing to do with the product itself. Why do we have trademarks? Well, it helps to regulate commerce, but more importantly, it allows somebody who's selling a particular product to put their logo, their name, their stamp on that, and that's what helps to differentiate those goods from somebody else's. So there, you've seen these trademarks before. iTunes, GE, McDonald's. Take Nike. Used to be Nike above it. Just do it, and then a swoosh. And then watch what Nike did over the years. First they removed their name, and they removed just do it. If you tend to see that, you already know what it is, right? Mm-hmm. But that took years and years for them to develop that. Starbucks for coffee. You don't even have to see the name Starbucks for coffee. The little mermaid up at the top. Sometimes it's very, very, very well known. Not a coffee drinker, so I don't know. Shell oil. Right? There's a whole bunch of trademarks out there.
Dairy Queen.
Right? Just think about those. You run across those every single day. Yes.
So, we were watching the news, so it said like you can't make you have Dairy Queen, you can't make a Dairy King. But how does a trademark protect that?
What that comes down to is we compare two things. We compare the goods, so let's call it ice cream, and then I compare the mark itself, Dairy Queen and Dairy King. And the test for the judge to use is the likelihood of confusion. Would somebody who's buying it think that one is the other, or made by the same, right? And that's twofold. One is the trademark examiner, before they grant you a registration, only if it's federally registered can you put a circle R on it. If it hasn't been registered, then you use a TM. Or oftentimes they don't put anything on it, all right? But that trademark examiner first takes a look at it and says, similar goods and services, here's Dairy King out there. Should I let Dairy Queen have that registration or not? That's the first decision you make. Yes?
I was at an ice cream place and they called a sundae like the same thing as they call it at Dairy Queen.
Mm-hmm.
I wasn't sure if that would be like infringement or if that would just like be, because it's just one store, it's not a chain, so it would be like too small to worry about.
Correct. And that's too small to worry about is a good thing. So you could have what we call a technical infringement. And somebody may not be able to find every single technical infringement out there. But if that becomes a big chain store and it begins to hurt their business, then they're going to go after them. Right? So anyway, you guys see these all over the place. But think of all the marketing that's behind that. Lots and lots of things, right? So, Watch somebody like Apple. You guys are probably a little too, but anyway, it started way back when as a shuffle, right? Then we went to Nanos, then we had an iPod Touch, the MacBook, they all have their Apple logo on there, right? Their computers oftentimes, they're different, but it's not that their computer may be better than somebody else's. But boy, everybody knows it when they see an Apple on there, right? Then there comes the iPad Air, or the iPad Mini. And now we've got the iWatch, or I should say, the Apple Watch, right? So, this one's so new, just got introduced, what, a few weeks ago? Right?
A month ago.
So there it is, a month ago. And they, I'm going to go way past it. Anyway, we'll check ahead here is, watch what Apple is doing to try to protect that. Okay? And we'll run into that. All right, copyright, the next big area. This prevents others from copying formal expressions. We talked about the Romeo and Juliet and the idea of West Side Story. What happens is, as soon as I put pen to paper, or as soon as I type it up on my keyboard, in what we call fixed intangible medium, once that occurred, copyright exists. Right? So you're taking notes. If she happens to look over your shoulder and she begins to copy from your notes, word for word, that's a copyright infringement. You don't have to register. The copyright exists right then and there. Ah, it's there. Staring down, right? Yes.
Does that mean if like someone cheated on a test, it would be copyright infringement?
Alleged. It becomes plagiarism, which is kind of a form of it, right? Copyright infringement really is for big commercial ideas, not in the classroom. But always think of the fact that once it's, as we say, fixed in a tangible medium, that could be tape recorder, it could be in an MP3 player, it could be any type of recording, DVR, right? It could be handwriting via the computer. So who wants copyrights? Artists, composers, writers, architects, software developers? I can guarantee you, when they first came up with copyright, software developers didn't even exist. Computers didn't exist. Okay? And so the law has changed and adapted to provide protection for them also. And it's all being protected through, again, the Constitution. To promote the progress of science. Well, really, it's an expression of an idea. Is that science? Probably not. Again, it secures it for limited time to authors. It's known as the Winnie the Pooh rule. Every time that A.A. Milne, who was the author of Winnie the Pooh, it used to be 75 years after the life of the author. All of a sudden, that was going to expire, that copyright. Disney goes back to Congress and said, hey, we need some more years on this. And all of a sudden, it went up to 90 years, to 100 or 110 years, whatever the thing is, you know? But they're always trying to get a little bit more protection because they get to license the Winnie the Pooh character. Congress controls that through 17 U.S. Code, and again, that's a federal action, so that can go to federal court. These are the different types of things that get copyrighted. Literary works, music, right, dramatic works, pantomimes, choreographic works, pictorial graphic sculptures, motion pictures, sound recordings. And, again, anything fixed in a tangible medium, many people never register their copyright. But if you do, you can go to the U.S. Copyright Office, which is at the Library of Congress. Right? And you submit a copy there, and then if need be, they can make a comparison between them. So why do you copyright things? Again, you want to compensate and reward those people who wrote the music, who wrote the book, who made a beautiful sculpture. You don't want people just copying it. Right? I will tell you though, there are some musicians out there, for example, who say, I don't want copyrights. I want it to be given to free for everybody. They're usually in the minority though. All right, the last one was trade secrets, where you protect that information because it gives you a competitive advantage. Trade secret is only as good for as long as you keep the trade secret a secret. This could last 150 years. Or it could last 2 days. And there's what? Probably one of the most famous of all trade secrets is the recipe for Coca-Cola. Right? And it's not that long ago, a few years, that a couple of employees who left Coca-Cola turn around and try to go to Pepsi and sell them a recipe for Coke. Right? Well, they got caught. And even when you go to read the court decision, they never talk about the recipe for Coke. It's Project N, whatever that stands for. Right? So, in summary, this is where you put it all together. We have 5 minutes here, all right? Put it all together. Somebody walks into my office and says, yeah, I've got this great idea for a new soft drink. Right? First off, what can I do to protect it? Well, maybe Coca-Cola there, that, and what it looks like, that could be a picture. I can protect that by copyright. The name Coca-Cola, either just as block letter form or in that stylized cursive writing, that label could become a trademark. The actual shape of the bottle, that could be a design patent. We talk about it as the type of a patent. How you actually make the bottle, that could be a process, for example, or it could be the machine that does it, so that could be a patent. Or maybe how you cap the bottle. The whole industry based on that patents on that. The recipe itself for the ingredients, that could be a trade secret. Then the overall appearance of it. What's famous about Coca-Cola? Probably most famous is that red and white color. Right? So they developed something that's known as trade dress, where it may not in fact be an actual registered trademark, but it's kind of a look and feel of what the product is all about. And if somebody copies that, that potentially is an issue too. We won't talk about domain names, but that's another way to try to protect it. So here, this is a, what's the name of the famous, sorry ladies, the name of the lamp, Tiffany lamp, right? So we don't have the color here. But they walk in the door and you say, how do you try and protect it? Well, the shape design can be copyrighted. Perhaps the lamp itself has electrical circuitry that can be patented. The sculptural base, if it's a real fancy shape, or like it has a Roman goddess as a part of it, that can be a copyright. Right? And this is the type of thing that you guys will be asked to do, right? They're going to take you in and say, hey, here's a new product. What do we do to try to protect that? Right? Well, I don't see a name associated with it, although it came out a month ago. So what they do? They went out and got a trademark registration for Apple Watch. Okay? Then, they turn around and make sure that they put that trademark everywhere out there. Now notice that watch itself, I mean that's generic. I have a watch, just like everybody else has a watch. But you put that Apple insignia in front of it, and all of a sudden that kind of becomes a special trademark. Right? It's what we call the house mark associated with the generic description of what that product is. And we got 2 minutes here, all right? So just for fun, maybe you guys have seen this in some trademarks. Did anybody ever know that from Amazon, it's A to Z, and that this is a big spot?
I didn't know it was a I didn't know it was an arrow.
You like it, these are fun. Nintendo's GameCube, right? It's nothing but a big G around the C or around the cube, right? So it's a game cube.
Oh, that's smart.
Right? Anybody ever seen their pictures in Google's Picasa?
No.
Right? Everybody knows what casa is in Spanish? House?
Oh, wow.
See the house in there?
I see the house.
And you've seen a camera where it's got the shutter?
Oh, yeah.
See, that's what this is representing, the shutter. I told you you'd like this part of the program. FedEx. Look at the hidden arrow in there. Has anybody ever seen the arrow sitting right there? Pretty cool, huh?
I'm never gonna look at these little
I've seen it.
All right, everybody's seen this one where the 2 people have a chip in their...
Yeah.
I've seen the 2 people.
Yeah. And there's their salsa right there. Hershey Kiss. Did you ever know that right here sideways is also a kiss? I'm not smart enough to figure this out. I went to another presentation, but they're fun. Toblerone. Anybody ever had Toblerone? Great candy, right? Well, it comes from Bern, Switzerland, take a look at the bear inside the Matterhorn. Kind of cool. I'm going to keep hurrying through these, sorry. Baskin Robbins. 31. My wife never even refers to Baskin Robbins. Let's go to 31 for ice cream. What are you talking about? Well, we're both right. Okay?
I usually say it's Baskin Robbins.
Northwest Airlines.
Oh, I see the things pointing to
The
the.
compass in there?
Yeah.
Circle.
It's pointing west.
Pointing north. This one I think is really cool. Pittsburgh Zoo. See the two over inside the tree there? Isn't that sweet? Goodwill. Did you ever notice that the G in the word is the same as the smiley face? Kind of neat. And then the Milwaukee Brewers for baseball fans, there's an M&B in there, huh? With that, you're ready.
Thank you very much. The gas we have.
Absolutely. Absolutely. Perpetual motion machine is something that you put this much energy in, and allegedly it runs forever and ever and ever and ever. Well, that can't happen. Physics, the laws of physics tell you that can't happen. So you can't get a patent on it either. Yes? No. Patents, once they expire, they're dedicated to the public because remember, you made a contract. In exchange for exclusive rights, I'm going to tell you and the rest of the world how to do it. Once that's done, time is up.
When you're talking about the patent and how you could improve it,
Yes.
if you improve it and like about the light bulb and put the tungsten wire, do you own the light bulb as well or just the tungsten
You
wire?
just own the tungsten. So the guy who had the tungsten filament, he couldn't even make that unless he got permission from the original patent owner. But the original patent owner can't make a tungsten filament without permission from the other guy. Right? So that way you kind of have a stalemate between the two, and that's why they have to get together and license it. Yes?
When a copyright expires, does it enter public domain?
Yes. Yes. And probably some of the most famous go to the art museums these days, right? The Rembrandts and all those things. Mona Lisa from Leonardo. Many, many, many years ago, he's been dead for a long time. That's actually in public domain. And many of the museums still in the States don't let you take photographs. I was just in Europe here recently. You go into all the famous art museums over there, they let you take photographs because there is no copyright associated with them.
So once your patent is expired, anyone can take the technology from, say, Apple and use it to create their own new company?
Yep.
Oh.
Yep. And sometimes, if this is what the patent is covering, what you do is you kind of tweak it and you make it different so you don't infringe on the patent. So that's why there isn't just one tablet out there. There's lots of tablets from lots of different companies. Samsung is obviously in a big, big fight these days with Apple over their iPhones, right? Well, there's lots and lots of patents on that, and that's been a fight that they've had now for 12 years, something like that. And there's different ways to protect different features of that phone. So,
once your 20 years is up, what happens to your company?
as long as you still make a good product, people still want to buy the product. So that's always important. But the patent kind of gives you that leverage, that leg up on everybody else. It gets you out in the market, people begin to know your name, then you use your trademarks to help you, right? There's a lot of people who buy apples today, and I tell you, in my view, apples aren't always the best technologically. Sometimes they are, but not always. And yet, people buy Apple just because that's the name associated with
Say if the school chair's patent runs out,
it.
and then I go back the very next day and my dad and I create the same exact chair with a different name, and I got it patented again, would it be mine?
Well, you wouldn't get it patented again because it's already been out there, right? So a patent examiner would say, sorry, it's already been out there and it's been patented and you can't get it. But as to a new name on it, let's call it the L chair. And you're going to come up and call it the blueberry chair. whatever, completely different names, there's no trademark infringement. But people won't buy the blueberry chair because they don't know what that is. But the L chair, they say, I know that one. Everybody wants that, right? So that's where the strength of the trademark sometimes comes into play.
So when does the Apple, like, where does it?
The trademarks are renewable. Unlike patents that expire in 20 years, trademarks go every 10 years. As long as you pay the money to the government, they'll renew your trademark for 10 more years. So you got 20 years on a patent, roughly. Trademarks are every 10 years, but they're renewable. Copyright is the life of the author plus X number of years, and it's up near 100. Change in trade secrets, they can last forever, but only as long as it stays a trade secret. Word gets out, trade secret's gone. Everybody's doing it. Thank you all. Hope I answered.